We're here to conduct our third installment of our chat with Jeffrey Cohen of the law offices of Cohen and Richardson. Thanks again for joining us.
Oh, my pleasure.
As the final installment in our three-part interview series, Jeffrey Cohen speaks about California laws pertaining to web hosters. So specifically to the topic of web hosters, and you being a lawyer in California, maybe you can touch upon the different laws pertaining to web hosters in this state as opposed to other states, and how they all differ and why they differ so much. Or do they?
Well, attorneys are state-based, so we're licensed by state.
Okay.
And the people in different states have the ability to create different laws. That's true with respect to laws that might affect the internet as well. Some states are a little bit more forward-thinking and are dealing with issues that other states haven't had to deal with. California, early on, with up north in particular, became a center of technology, and as a result, sort of faced some of those issues before many of the states throughout the country really did. So as a result, there's legislation that was put into place to protect consumers and to protect web hosting companies in some instances and other internet service providers earlier in California than in many other states. Most of what governs the dealings of an internet service provider is really federal law. A lot of it is federal law, and that's really the same throughout the country. So we have clients all over the United States and clients all over the world. And there are a few exceptions. Certain states have certain requirements with respect to privacy policies or disclosure of personally identifiable information that would depend upon, from a jurisdictional standpoint, where they're located. California is no exception to that and has a few rules of their own, pretty well thought out, logical rules. But by no means, I've heard sort of people say, stay away from California, don't use California law. I wouldn't agree with that at all, for two reasons. One, those laws apply to anybody that is collecting personally identifiable information or is, for example, advertising, sending commercial email to residents of the state of California, whether the company is a California company or not. So whether you specifically choose California in the agreements that you write or not, you still have to comply with those laws. And as a web hosting company that is serving clients nationwide or worldwide, it's really important to pay attention to all of the potential laws that could affect you where you're conducting operations, and not just focus on one particular state. For example, there's a law in California that requires a disclosure of if personally identifiable information is somehow inadvertently disclosed. You've got to make an immediate disclosure of the fact that information was disclosed to any California resident. Well, that's not just a requirement in California, but it's also probably a good idea. It's good, protects consumers certainly, and it also is going to keep that web hosting company out of hot water in the future, because at least you've fessed up and you've done what you needed to do to deal with the problem, and you've let everybody know what you're doing. I think that's just good business. Yeah. So, somebody in a state that doesn't have that requirement would still do well to pay attention to the California requirements of other states, and sort of make their call as they feel appropriate going forward.
So that law in particular, and correct me if I'm wrong, is it something like if 10,000 people have their information breached, then the hoster is responsible to contact all of these people and let them know that somebody has gotten their information, or something along those lines?
Not particularly. No. I don't believe there's a number requirement, but if there's a disclosure of confidential information, that there has to be an expedient effort to notify the parties of the extent of the disclosure. And as a consumer, you'd want to know that somebody got your information, so that if it's a credit card, you could potentially go and cancel it. Now, the question comes up, what is a disclosure? When has the information actually gotten out? Is this a piece of information that is confidential? Is this actually a disclosure? A competent web hosting company that really is concerned about these issues, or at least paying attention to these issues, is going to catch issues before they turn into issues. So, the easy questions are easy. If somebody, hacks your system and gets some information, I think there's a pretty easy answer to that. But if it's something less than that, and you've got a business owner, web hosting operator that's paying attention, they're going to be asking those questions before it gets to that point.
So that wraps up our 3-part series on internet law and litigation and how people can protect themselves, web hosters in particular. And I really appreciate everything you've told us today and shared with our audience. Thanks again.
Sure, my pleasure.
If you would like more legal advice from Jeffrey Cohen, please contact him at jc-whir@internetlitigators.com.